Further debate. The member from Dufferin-Caledon.
Thank you, Speaker. It's an honour to rise this morning to talk about anti-SLAPP. Now, I think for the purposes of people who are listening, though, I have to first do a bit of a legislative lesson on why we are not talking about the Auditor General's report. Very substantial damning. Can I use damning? Report came out late yesterday afternoon. It's all over the newspapers this morning, and I'm sure if anyone is tuning in now, they are questioning why we are talking about the anti-SLAPP legislation and not some of the terrible, terrible indictments in the Auditor General's annual report. It is, of course, because by legislative precedent, we must speak to the bills that the government bring forward. And today, of course, they brought forward the anti-SLAPP legislation, which means that I am not allowed to make reference and talk about specifics in the Auditor General's report because it doesn't relate to the chosen topic that the House Leader of the government has brought forward. So, to that point, I will talk about Bill 52, the Protection of Public Participation Act. I think it's important to put this bill in context. To give credit where credit is due, there have been a number of private members' bills, Speaker, on this very specific topic. One, of course, is from the now leader of the third party and the member from Hamilton Centre, and, of course, the government House Leader, the member from Ottawa Centre. Both in previous parliaments and previous governments have brought forward very similar legislation to Bill 52. We also had, I think it was Bill 83 in the previous government, where, to the minister's point, John Gerritsen, now retired, as the Attorney General, also brought forward this anti-SLAPP legislation. This bill came forward as a result of a report from 2010. So there was a panel struck at the request of the Attorney General to study how to ensure that we could actually come forward and bring protections for people who want to have a public voice in issues of concern to the general public, but also, quite frankly, protect the right of people who want to move forward on ideas or make changes to their own community. So it's, I think we would call it, to quote Rohinton Mystery, that fine balance. The Protection of Public Participation attempts to do that in its fourth reiteration, if you include the private members' bills. And I would like to take some time this morning to go over past cases that are commonly referred to when we talk about SLAPPs. So SLAPP, of course, is a short form for Strategic Litigation Against Public Participation. I think giving some specific examples of SLAPPs, or at the very least what are commonly accepted as examples of SLAPPs, will be beneficial because it allows us and our constituents to understand just what it is we are discussing here today. I know when I've spoken about this issue with people before, it often falls flat. If you have not been part of or the victim of a SLAPP, it's probably something that you don't spend a lot of time thinking about. To be honest, it can be considered rather legal and trivial to the average person, but that's why it's important to reflect on some specific SLAPPs, because it puts into context the issue and allows us to see the human side and the human impacts of this. When we debate these things in the legal lexicon, it can often become muddled and abstract. But when we focus on specific examples, specific people, that's when we can truly start to see what difference legislation can make. I also think it's important for our constituents and the people watching at home to know how SLAPPs typically come about, so that they are aware of what a SLAPP is and when or how to know how to spot one. So that's why I will be using some of my time to reflect on past SLAPP cases and their various effects and motivations. I also intend to cover the bill itself and then analyze how the measures contained within Bill 52 match or don't match with the problems demonstrated by the examples I will go over. Some of these cases, as you will see, are quite daunting, and the fact of the matter is that we need to make sure this legislation is capable of doing what it is meant to do. Because no Ontarian should have to choose between having a say on a development or a change in their community or risking being sued into financial ruin. Finally, I will conclude by summarizing why SLAPP should absolutely be stopped from occurring, and thus why this legislation should be supported by all members of the House. Bill 52 is a reintroduction, as I said, of Bill 83, which died on the order paper when the government called the election this spring. It's important to mention that many other jurisdictions have some form of anti-SLAPP legislation already in place. For example, roughly half of the states in the U.S. have some form of anti-legislation already in place. In addition, England and Australia, which, if you're a legal expert, are more closely matched to our system here in Canada, England and Australia have some form of anti-legislation as well. Speaker, Bill 52 and its predecessors stems from the Anti-SLAPP Advisory Panel, which submitted its final report to the Attorney General over 4 years ago, October 2010. Don't ever accuse the Ontario government of moving quickly. And of course, that's why we are really talking about here today, SLAPPs. A SLAPP is a lawsuit that's brought against an individual for the primary purpose of silencing that individual's opinions, public opinions. SLAPPs are almost always some form of libel or slander allegation, and almost always are for unrealistic and unreasonable amounts and damages. That's the point of a SLAPP. Not to win the lawsuit, but rather to scare the defendant so that they dare not speak out against a claim. The reason that this is particularly problematic, however, aside from a gross misuse and waste of taxpayers' dollars by clogging down our justice system, it's because it's not only an injustice to the defendant, but also to the community and free speech. This is because the community's planning procedures are manipulated. Community members who could have valuable contributions to make are instead intimidated out of commenting. Another word for the SLAPP is the, I can't remember, silent, so the ability to silence someone. Cease and desist letters, there's all kinds of fun ways to say it. The end result is a community planning process without the community. This is an entirely undesirable situation, Speaker. That being said, while typically SLAPPs involve developers and residents, there are also a number of instances and examples where this is not, in fact, the case. But I will get into that further later on in my details. For now, going into a discussion on past SLAPPs, please bear in mind the key factor here is whether the lawsuit's prime function is either to prevent someone from participating in a public process or to punish them for doing so. That is a certain principle that's important when discussing SLAPPs, that an individual has had their rights to express their opinion severely limited due to coercion. I would now like to move on and discuss two specific SLAPP cases, very different in their examples. They are unique from each other because each of them involves a different type of claimant pursuing the SLAPP. They are identical with one another, however, in that in each case the claimant has clearly pursued litigation for the purposes of silencing or punishing the defendant. It is this second point that primarily qualifies each as a SLAPP. In all cases I'm about to discuss, however, I'm not going to refer to either of the litigants by their names, as I don't believe it's relevant to the purposes of Bill 52. These cases are to illustrate SLAPPs, not to consider the particular individuals involved. As such, I will refer to the party bringing forward the slap as the claimant and the party the slap is being used against as the defendant. The first slap I'd like to discuss actually occurred in British Columbia. This slap arose from the following context. The claimant wants to convert his land, which was forested, into farmland. To do this, however, he had to dump approximately 750,000 cubic meters of soil on his property to properly level it so that it would be sustainable for farming. But in order to do this, he needed a permit. And so, in October 2009, he submitted a permit application to his local township. Now, the defendant in this case, owns land very near to the claimant's property. When the defendant became aware of the claimant's permit application, she became quite concerned about a possible negative impact on the streams that flowed through his land. The defendant also happened to be a member of a local organization whose mission it is to protect and enhance the integrity of the watersheds in the area. So the defendant decided to take action against the claimant's permit application. Consequently, the defendant and the local water preservation organization she was part of began speaking out against the claimant's permit application. The organization came out with written material opposing the permit, and the defendant produced a report outlining the potential damage that the claimant's permit may cause to the local watershed. There was also a meeting held where the defendant spoke about her objections to the claimant's permit application and her concerns for the wider region. In light of all of these developments, the local township decided to put the claimant's permit application on hold. The township argued that it needed more time to measure the environmental impact of the application. On September 1st, 2010, 2 weeks before the township placed the permit on hold, the claimant sued the defendant, the organization, which she was involved, and another individual, claiming $13 million in damages against all three. The claim against the defendant herself was for $550 million. The defendant's lawyer soon advised the claimant, via letter, that his lawsuit was bound to fail because it disclosed no viable cause of action. In essence, the claimant had no case, as there were no facts to support the lawsuit. In February 9th of 2011, the defendant even offered to pay the claimant $2,000 in full settlement of his claim, but to no avail. The claimant made serious allegations against the defendant, including that she made unfounded and false statements to local residents about his permit application. The claimant argued that this was done for the purpose of gathering signatures on a petition opposing his application and for the purpose of intentionally harming him. He also alleged that the defendant organized public meetings only to spread false information about his permit application, and that the defendant made false statements about the permit to the local member of the provincial legislature. The claimant also argued that the defendant endangered the public by using a low-flying aircraft to photograph him and act maliciously by making false statements to make him lose his farming career. All in all, the claimant basically argued that the defendant defamed him and conspired to injure him and his property. The claimant also made similar allegations about the local water preservation organization as well. So, to recount, an individual, the claimant, sought to obtain a permit to alter his property, and their neighbor, the defendant, objected to this alteration on the basis that it would have had a negative effect on the larger area in the community. Speaker, clearly this is an example of an individual staying involved in their community and trying to participate in its growth and development. In other words, this was clearly an individual participating in a public matter, namely whether or not the claimant's proposed alterations would have an effect on the larger area the public inhabits. Thus, by undertaking such vigorous and overwhelming legal action in response, the claimant has already partially demonstrated this case to be a slap, as one could conceivably argue that the claimant is attempting to punish the defendant via a lawsuit. What further demonstrates this to be a slap, however, is the claimant's clear lack of interest in actually pursuing the case as a legitimate legal matter. And this is a very important part of Bill 52, that shortened process to ensure that the legal system can basically do a review and say, is it a slap or isn't it? Because there are going to be examples, Speaker, and we all can name some, where people and businesses have been defamed, and they have absolutely every right to defend their character and their business. Bill 52 does not prevent that. For example, when the defendant brought an application to dismiss the claimant's lawsuit and provided notice to the claimant, he didn't attend the hearing. That being said, all the material the claimant filed with the court was still considered, even though he didn't show up. What the judge determined was that the claimant had provided no evidence of his allegations against the defendant. The judge eventually concluded that the claimant had merely asserted what he believed had occurred, with no evidence to support his claims. The judge determined that not only had the defendant not acted maliciously or intended to harm the claimant, but was instead merely exercising her right of free speech to disagree with the claimant's permit application. And as a result, the defendant was naturally voicing her opposition to the permit application and had done nothing unlawful whatsoever. Clearly, Speaker, there can be no mistaking this for anything short of a typical SLAP suit. To demonstrate the negative effect that SLAPs can have, however, consider the fallout from this one example I have discussed. As a result of the SLAP brought against her and the ordeal she went through fighting it, the defendant ended her community involvement out of fear that she may again be the target of another SLAP. She stopped attending the water preservation organization's meetings and stopped participating in other environmental causes. Furthermore, she no longer gave advice to her neighbours on similar issues and discontinued her volunteer work. Just think of the negative impact this slap caused the defendant, Speaker, to say nothing of the community. Bless you. I know here we have an extremely engaged citizen who is concerned about her neighbours and her community's well-being. And thanks to a slap, she is totally shell-shocked into foregoing all efforts to improve her community. I think it says a lot, Speaker, about the kind of damage slaps can cause. The defendant ended up paying over $20,000 in legal fees and over $4,000 in disbursements due to this slap, and all because she wanted to be involved in her community's future. And that is just the individual defendant in this case. When it comes to the organization she was involved with, the damage is, respectively, just as onerous. The slap had a severe negative impact on the work of the organization, as all of its time had been spent on defending the lawsuit. There was little time and resources left to devote to organizing other activities or initiatives. The slap basically silenced the organization, as it did not speak out against the claimant's permit application from the moment the slap was filed. Some would say that was the complete and 100% intention. And unfortunately, as a result of this litigation, the organization was forced to consider ceasing operations altogether once the slap had been settled. Directors ultimately of the organization did buy public liability insurance, mostly because they were concerned about future slaps or litigation chill. And eventually on May 25th, 2011, the claimant's claim was dismissed with costs awarded to the defendants. Speaker, this is the epitome of a slap. Long, fruitless, expensive, and highly damaging. This legal action was clearly brought forward to limit the defendant's ability and desire to participate in public matters. This is an example of a private individual pursuing a slap against another private individual. And again, it is for the same reason as the next example, limiting or stopping public participation. I want to pause for a minute and talk briefly about how technology may impact Bill 52. So because this bill is a result of a report from over 4 years ago in 2010, because it is basically a reintroduction based on Bill 83 and the last government, I think that we actually have an opportunity at the public participation stage, and it occurred to me, I truly hope that we have full and fulsome public hearings on this, because if nothing else, this anti-SLAP legislation is about the ability of the public to participate in a discussion for their benefits. And I would hate to see the government have closure or suggest that we need very truncated public hearings on a bill that is all about public participation. I'm not going to try to foreshadow what is going to happen with discussions in the House leaders, but I can assure you that if we end up having a very limited public hearing process for Bill 52, I'm going to make some hay with that, because that's all wrong. This is all about public participation, and we better have a committee that actually travels and is prepared to listen and is prepared to come forward with amendments. I want to talk briefly about Twitter and Facebook, because I don't, in the 2010 report, they don't talk a lot about how that impacts SLAPs, if Twitter and Facebook posts would be considered when they talk about defamation or have issues there. So I think there is an opportunity, Speaker, for some positive amendments that will basically acknowledge the role that technology has in both participation at a political level, of course, and as an aid to informing our communities. But I digress. I'm going to go to my next example. This example offers perhaps the most startling but also clear case of a SLAP example that I can discuss here today. In this case, the claimant was the mayor of an Ontario town, so a politician, and the defendants were members of the town's news media. One of them was also a former town councillor. In essence, Speaker, one of the defendants was known for commenting on the town's municipal issues, not unusual in our local papers. He frequently wrote articles dealing with municipal issues as a reoccurring column that was published on the internet, on a local website focused on current events in the town. The other defendant was a former town councillor and was the website's moderator. Throughout the mayor's first term in office, both defendants were vocal critics of the mayor's policies, and in 2010, the mayor was running for a second term. Election day was set for October 25th. On October 20th, 2010, a little over 2 months from the election day, 2 months from the election day, one of the defendants wrote an article that was critical of the mayor and posted it on the website. In it, he prompted the website's visitors to write over 50 comments about his original article. As is typical with such sites, the comments on an article appear directly beneath the article and are published online as soon as they are submitted. There were many comments on the website in response to the article, and many were far more critical of the mayor than the article itself. Furthermore, many of the commentators used pseudonyms and fake names so they didn't have to identify themselves. Then, on September 15th, 2010, a little over a month from the election day, the Town Council passed a resolution authorizing the town solicitor to, quote, retain external legal counsel to take any and all actions to bring resolution to the matter of defamation of the mayor. What is basically meant was that a SLAP would be commenced against the defendants and the town would pay for the legal fees, since the town solicitor was retaining the external legal counsel to pursue the legal action. Surely, one can see, Speaker, how, as I mentioned earlier, this particular example gives us perhaps the clearest example of how a SLAP gets its name. It's pretty hard to find a more clear-cut case of an individual's right to participate in the public process being violated than when an elected politician sues someone for criticizing them in their elected role. Why, Speaker, dare I say, just about every member in this chamber would be embroiled in a SLAP with one another if this is how we operated here. I shouldn't kid, but you get my point. It is preposterous to think that a politician who's elected by the people is so above criticism that their detractors should dare not speak against them, lest we risk being sued. That, Speaker, is a SLAP. Anyway, on October 8th, 2010, now a little over 2 weeks before the election, the mayor proceeded with the lawsuit. Similar to the last SLAP example I gave, where I pointed to a lack of legal follow-through on the part of the claimant as further proof that his claim was indeed a SLAP, here again we see a disregard for typical legal procedure. Now bear with me here, Speaker, because this may be a little technical, but it's definitely an important point to make. I'll try to get through it relatively quickly, but I certainly hope my point is not lost to the viewers. And remember, this legal action was commenced by the mayor a little over 2 weeks from Election Day. Okay, so typically, most legal actions of this nature are initiated by having what is known as a statement of claim issued. In this case, however, the action was initiated by having a notice of action issued under what is known as Sub-Rule 14.032. I'm sure the legal minds in the chamber are loving this. Now, what does this matter, you may be asking? Well, here's why. Because the Sub-Rule 14.32 states the following, quote, where there is insufficient time to prepare a statement of claim, an action may be commenced by the issuing of a notice of action that contains a short statement of the nature of the claim. So the question, Speaker, is why was there insufficient time for the mayor to initiate the legal proceedings properly? The answer, I think, is obvious, because the only timeline of relevance was the impending election, which was now, as I said, under 3 weeks away. The mayor sued the 2 defendants, as well as 5 others, and claimed $6 million in damages from all the defendants. 2 defendants were served with the notice of action on the same day the action was commenced, October the 8th. Whereas one of the original 2 defendants was served with the notice of action on Thanksgiving Sunday, October 10th, 2010, while he was having Thanksgiving dinner with his family. And here's the catch. Remember Sub-Rule 14.032 that I just mentioned? Well, there is an accompanying rule, Sub-Rule 14.34, which very clearly states that the notice of action shall not be served separately from the claimant of statement of claim. So the serving defendants with the notice of action, but no statement of claim, directly contravened the rules. My point of getting down into the weeds with this is not to bore you or my colleagues, I promise. Now, the reason I bring this up is because it demonstrates quite clearly that in this case, the mayor was far less concerned with taking the appropriate legal action properly, and instead far more concerned with simply proceeding in any way possible, as long as it was before the election. It should come as no surprise that when one of the defendants swore in an affidavit that the mayor commenced the legal action in order to silence him days before the October 25th, 2010 election. Moreover, the mayor did not file an affidavit in response to a motion by the defendants to have their legal costs recovered, nor did the mayor give any evidence that her motives were that her motive was not to silence her critics as Election Day quickly approached. The defendant in this instance outright alleged that this was a slap. Furthermore, the defendant argued that because this was a slap, they were entitled to an elevated award of costs. The master, providing over a motion by the defendants to have the mayor pay for their legal costs, ultimately sided with the defendants resoundingly. The master found that the evidence was indisputable. The master was convinced that the mayor brought lawsuit forward in her capacity as mayor of the corporation and the town. Moreover, because the mayor had access to the town's municipal money until December 14th, 2010, the taxpayers, in effect, funded this anti-SLAP, or this SLAP litigation. This is a totally clear case of a SLAP being used to silence and intimidate those of a different view. And because the party initiating the legal action is a politician, it became a SLAP even more clearly, since they have a large vested interest in silencing their opponents. Even more shocking in this case is the fact that technically this legal action was commenced without complying with the prior notice provisions of the Libel and Slander Act respecting broadcasts. The mayor expressly sought damages of $6 million from the defendant. But the presiding master took issue with this, pointing out that in an action for damages, it is unusual for the plaintiff to claim a specific amount of damages in the notice of action. As you can see, Speaker, it's difficult to not see this case from the beginning as nothing more than a desperate and ill-advised scheme to silence the mayor's political opponents in the lead-up and including the municipal campaign. Perhaps more tellingly, the master concluded that the legal action initiated by the mayor was indeed slap litigation. Ultimately, this slap was put to rest when the mayor dropped the case and delivered a notice of discontinuance on October 17, 2011, over a year from when it was first initiated. And really, what good did it serve at all? Here was this slap, sucking precious court resources and time, dragging on for over a year when it had absolutely zero credibility. As I mentioned earlier, the second example I have given is a clear case of an elected or public official using a slap against an individual in their community. Clearly, the mayor was only interested in silencing her critics prior to the election, and she resorted to outrageous measures to do so. So while I have now spoken about an example of a private individual pursuing a slap against one another and a public elected figure pursuing a slap against a private individual, both of whom were trying to silence their critics, I do understand the need for Bill 52 because, as we've seen by the examples I've listed, these can take many months or even years to resolve. By instituting a timeline to decide if a matter is a slap, Bill 52 will go a long way to ensuring these frivolous claims are taken care of. So now we've gone over two slap examples. One a private individual pursuing a slap against another private individual, one a public elected official pursuing a slap against critics. And Speaker, I think the second one is actually more egregious. Now, we as politicians, as public figures, basically sign on to agree to a public review of our job, quite frankly. We do that municipally, we do that provincially, we do that federally. And for an elected member who is serving in public service to suggest that they can use town resources or, take it to a different level, provincial resources. Imagine the outrage we would have if the various ministers who were chastised in this Auditor General report actually attempted to sue the Auditor General. There would be, I hope, riots on the street. People would be so offended that our elected officials, our appointed cabinet ministers, can't take the heat and instead want to silence their opposition and their opponents. There would be no stomach, Speaker, in Ontario for that kind of action. So we are, by putting in place Bill 52, attempting to say, you as an elected official cannot use your staff resources, your municipal funded resources, provincially or federally, to, in effect, silence your opposition. I think this, in a very specific way, demonstrates that a slap is not always a big development company trying to silence individuals. This is often held a stereotype that is simply not true, as I've demonstrated here today with my examples. While yes, there are instances where the situation follows that narrative, there are also other vastly different contexts for slaps as well. My point here is that a slap is something that could be pursued by a variety of individuals for a variety of reasons, all which have to do with silencing someone's public views. That's important to bear in mind when considering Bill 52 because it becomes particularly relevant to institute a mechanism for addressing potential slaps, and that's something Bill 52 does. That is why Bill 52's proposal to institute a 60-day time limit on deciding whether or not a lawsuit is a slap is a critical component of this legislation. But that's not the only good proposal in Bill 52, and I'd like to take some time now to go over the bill itself. Now that we've had some chance to review some common examples of SLAPs, I think the viewers at home and my colleagues here in the chamber will perhaps have a better understanding of how Bill 52 could help remedy the problem SLAPs pose. Bill 52, the Protection of Public Participation Act 2014, lost a year there, sets out to combat SLAPs by amending multiple pieces of legislation to basically create a process to determine if a lawsuit is a SLAP and to have it dismissed accordingly, if so. In order to set up this process, Bill 52 amends the Courts of Justice Act to allow for fast-tracking of motions to determine whether legal actions are in fact SLAPs. Essentially, how Bill 52 will work if enacted is that if a defendant believes they have been targeted by a SLAP, they will be able to bring forward a motion to have the presiding judge determine if, in fact, the legal action is a SLAP. If the judge determines the action to be a SLAP, then the judge shall dismiss the legal action within that 60-day time period. It remains incumbent on the defendant, however, to prove that the legal action brought against them, in fact, is a SLAP. If they are unsuccessful in proving this to the judge, then their motion will be dismissed and the case would proceed. It's also important to note that when rendering a decision on this motion, the judge would be able to award compensation regarding costs on the motion if they deem it appropriate. Moreover, the judge would also be able to award the defendant damages as the judge considered appropriate if the judge determined that the claimant brought an initial legal action forward in bad faith. A key component of Bill 52 is the 60-day timeline it passes on the motion for determining if a legal action is a SLAP. This timeline is essential for ensuring that SLAPs do not bog down our already overburdened court system. And if I have a concern with Bill 52, this is it. I don't want to be in a place where we are expediting one legal proceeding and then in 2 years find out that we've actually made it worse for another legal proceeding. I'll pick on sexual assaults. I don't want this to be a case where the courts end up, by law, having to deal with one group of issues and then have another group have a longer waiting list. By instituting a 60-day timeline for a decision, Bill 52 ensures that vexatious and unwarranted SLAP suits are dismissed in quick order. That's a central premise of Bill 52, I would suggest, and an important one. Another reason why the 60-day timeline on the hearing of the motion proposed under Bill 52 is so critical is due to the tribunal connection Bill 52 establishes. I'll confess, Speaker, this is one section of the bill that does make me somewhat uneasy. Bill 52 establishes that if the claimant has proceedings before a tribunal, and I'll pick on the OMB, then the defendant moving the motion to dismiss the legal proceedings can provide written notice to the respective tribunal informing them of the filed motion. At that point, the claimant's proceedings at the tribunal are deemed to be stayed until the motion is dealt with. My reservations come from the thought that this measure could potentially lead to backups at multiple tribunals. Because in theory, you could have multiple instances of these motions being filed and thus multiple proceedings being stayed at other tribunals. Again, though, that is why the 60-day timeline is critical. Because we must be mindful that balance is the key to situations like this. If there was no 60-day limit, then a claimant's tribunal proceedings could all be stayed indefinitely while the motion proceeds, only to, in the end, be vindicated if the motion was defeated. Whoa. Okay, I keep talking until you stand up. That wouldn't be right, however, so having the 60-day timeline ensures that these motions are dealt with. Bill 52 amends two other pieces of legislation, the Libel and Slander Act and the Statutory Powers of Procedure Act. The Statutory Powers of Procedure Act is amended to provide that submissions for cost shall be made in writing. The Libel and Slander Act amendment, however, is somewhat more significant.